Ladies and gentlemen, this is going to get absolutely amazing. Hello and welcome back, your lovely faces, to another video here on the channel. In the condensed live stream which we're going to be doing in this video, just really quickly, we didn't really go over much from that we've already done videos on earlier in the week, but we just updated a few things that Amber Heard, she has gone along and she has asked the courts to play nice with her so they can speak to the LAPD in a face-to-face meeting, and she wants to get the information from them, which they've basically said no, jog on, which is just amazing. But this video, ladies and gentlemen, oh my days, this is just absolutely amazing. Remember that we said that she was trying to, subpoena Twitter? Just so she can get over 200 Twitter accounts, just so she can say, all these people are from the same IP, they're all the same person, Johnny Depp has hired them, he's paying them all to say horrible things about me. Well, it's kind of funny, since that we're all here and we all talk to each other, it's like, wow, okay. And this is coming from Laura, so let's spin this around. Update, Johnny Depp VAH, Twitter subpoenas. It's huge fishing expedition and Twitter shouldn't allow any of it. No one has a right to randomly say, I don't like the way these 200 accounts tweet about me, so they must be bots or organised by Johnny Depp's agent to smear me. And these are a couple of the counterclaims which she has said that Mr. Depp and or his agents acting on his behalf have directed both authentic and inauthentic social media accounts and or non-human controlled bots to target her Twitter account. Many of these accounts both smear and do this to her, while simultaneously promoting and praising Mr. Depp's agent and attorney, Adam Waldman. That's because Adam Waldman is not stupid. That is because Adam Waldman doesn't go on TV and say stupid shit, say I've donated money when you haven't. Especially when it's in the millions of dollars, closer to 10 and, more than 5, which is absolutely crazy. If you can go online and say, oh yeah, I donated money, but I'm not going to show you the receipts, but then that charity comes out and says they haven't donated shit, and then you're like, oh my god, he's attacking me. Yeah, this is how stupid AH and her law firm are now. And it goes on to say about, she's is interfering with her reputation. Her reputation was already crap. But then obviously you got the other parts of it, going from all the attorneys, for AH and everything else. That is just so funny, because obviously Laura then asked Twitter support. I am not a bot nor an agent and entitled to express my opinions, informed from audio tapes, court documents and transcripts, and I do not want any of my information given out. Updated this to Twitter opposition responses to AH's lawyers. So this is what we got. So this is from Twitter's lawyers. Dear Mr. Cogger, we represent non-party Twitter and are in receipt of your subpoena dated September the 11th, 2020. For the reasons stated below and for those discussed during our phone call, Twitter objects to your subpoena. Please contact me to meet and confer if you disagree with Twitter's objections. First, Twitter objects to the definition of communication and document as overbroad and calling for information covered by the attorney-client and work product privileges. Second, Twitter objects to the subpoena to the extent it seeks information that Twitter is legally or contractually prohibited from disclosing, including information that would require Twitter to breach confidential contract, protective order, settlement, or other duty to a third party to maintain privacy and or confidentiality. When everyone signs up to the Twitter terms and conditions and the terms of service, it states in them, Twitter cannot give our information to anyone. So jog on. Third, Twitter objects to the subpoena to the extent it improperly purports to require the disclosure of documents containing proprietary or confidential information, trade secrets, or information implicating third parties' privacy rights. Plus, here in the UK, we have the whole, the whole GDPR and all this kind of stuff now, which they can't do it unless they ask us, which just goes to show how stupid AH really is. Fourth, Twitter objects to the extent your subpoena seeks information that it does not retain in a producible format. Fifth, Twitter objects that your subpoena is overbroad. All discovery requests must be relevant to a claim or defense on the subject matter of the underlying action. Then it goes on, doing all the codes, what they need, what they want. 6. Twitter objects is that the subpoena is unduly burdensome. Courts recognise that non-party discovery must occur only if the information sought is not available through discovery from the parties to the litigation themselves. They can't do it. Oh no. 7th, Twitter objects to the extent that your subpoena seeks electronically stored information that is not reasonably accessible because of undue burden or expense. Again, all these now are basically telling Amber Heard and her law firm because they know for a fact they can't do anything. And again, number 8, Twitter objects that you have provided no documentation demonstrating that the court considered and imposed the First Amendment safeguards required before a litigant may be permitted to unmask their identity. And as you can see, it goes on page 3, feel free to contact me on the telephone number or email address above if you would like to further discuss. So that's what we have by there, and I just think that is absolutely glorious. But I believe we have AH's response, which is again just like, what the hell is going on with her? She is so stupid. AH responds to Twitter's opposition. So, this is what we got. Mr. Is that Belcher? I do apologise if it's wrong. This letter will serve to respond to your correspondence on November 10th, 2020, in which your office asserted objections to the subpoena dated this. So, response to Twitter's first objection. The subpoena does not seek and is not intended to seek the production of documents that are protected by the attorney-client or attorney-work product privileges. The subpoena does, however, require that a privilege log be served with Twitter's responses and production to the extent that such is applicable. We do not request production of any material which Twitter believes to be the subject to either these privileges. So straight away they're like, oh, we don't want this. Twitter has already said this is what they are. So they're not going to have it. Twitter are going to go back to them and be like, haha, jog on, love. And it goes on to all the other ones. Basically, they're like, oh no, this is not what it means. We want this. And each time, it's just so goddamn funny. And it's kind of funny that with this one here, they actually put in the Twitter.com rules and policies. Which, again, Twitter are not allowed to give out information like their names, email addresses, all this. Because they're not allowed. And it carries on, just all their other objections. And to be honest with you, they try and go along. And it's just like, come on now, guys. You are literally kicking yourself in the nuts here. And you're shooting yourself in the head because it's so goddamn stupid. Everything that they're doing here is just ridiculous. Now, as I said, it cannot be understated, that the subpoena does not seek any content of user communications. That's what they've asked for. They want all these people's names and addresses and their IP addresses. No, they are not going to have it. And as you can see in the comments, her team's response to Twitter's fifth objection, they state AH filed a counterclaim of defamation on Johnny and is going off of the Virginia Computer Crimes Act and seeks relevant information. But didn't the judge throw that out? Yes. As you go by here, every single person that subpoena list should tweet to Twitter demanding that AH does not receive it. In the US, Europe, IP addresses are covered in DPA, which they are. She is crazy, vindictive narcissist who could pay someone to hack them using their IP at Twitter. Which is very true, and as you can see, everyone now is just like, yeah, this is great. But there's one thing I did want to go into, because this is what Tug says. Where is it? I believe it's back by here. So, myself, Tug, a lot of us, we follow Nick Recader, who is, he's just so funny, and he's awesome, and he is a lawyer in Minnesota. So Tug put onto it, hey, Recader Media, what's the legality on this move? AH asked Twitter to unmask hundreds of users, claiming they're bots controlled by Depp. Can someone sue for this obvious intimidation tactic? And Nick actually came back. It's possible. Twitter is typically pretty resistant to these requests. Suing her would probably just unmask the person anyway. Well, again, Nick is actually very right there. Like I was saying, they can have all my information because, again, go on, go for it. Doesn't bother me. But again, no, seeing what happens would be the funniest thing after it. And I think if a lot of us just got together and, they're saying this. Just say, Twitter, this is wrong, I do not give my permission for this, they haven't got a leg to stand on, which is just always so funny to see. If you are new to the channel, please like and subscribe. Hit that notification bell for future updates, and I'll see each and every one of you soon.